So again, I want to thank Abdul for reaching out to Diane and I to make this presentation. And my name is Ron Kruzeniski. I've been the commissioner since 2014. And as Abdul mentioned, with me is Diane Aldridge, who is the deputy commissioner, and she has been with the office for some 18 years. She will be giving most of the presentation here, but I wanted to take part um, because we're sort of entering into new territory and making this presentation to you. And I need to explain that a little bit. With First Nations and tribal councils, we are aware that First Nations have certain rights and certain obligations, and they negotiate with federal governments and provincial governments, and they recognize certain federal laws and may not recognize all provincial laws, all those things. So uh, and, and not always being bound by provincial laws, we need to talk today about the Health Information Protection Act and determining who is bound and who is not bound can be a little difficult when we're sort of into the whole structure that we have in the province. So we may say to you today, the Health Information Act applies, but that's just the short form for us kind of saying it applies to many people in the province, and whether it applies to a particular First Nations clinic or not is probably a matter of policy or bylaws. Um, we've discussed that with Abdul and learned just how complicated things are. Um, if you have a medical clinic on a First Nation, they may not necessarily be bound by HIPAA unless they choose to. But if the doctor comes from the Saskatchewan Health Authority, that doctor would be bound. And if the nurse comes from the tribal council, is paid by the tribal council, they may or may not be bound depending on policies of the tribal council. So it can get kind of complicated, and I do say to you now that from time to time, if you need clarification, I would encourage people to, talk to their lawyer to get a reading on a particular situation. And when we get to the question and answer part, from time to time, Diane or I may say, um, yeah, that's kind of complicated. You need to get legal advice on it. So we may have to end some of our questions that way. So again, recognizing the complexity of relationships and that sort of thing, we're going to talk about the Health Information Protection Act, where many health professionals in the province are bound, but individual First Nations may be making their choice. Um, I wanted to close before I throw it open to Diane that after all this discussion, I would really encourage each First Nation to have a policy or a bylaw, the tribal council to have a policy or a bylaw to clarify to what extent they recognize or want to work cooperatively with the rules in HIPAA. I think that sort of clarification would help all staff, all health professionals, kind of to know what what the tribal council thinks, or what a particular First Nation thinks, or what a particular medical clinic thinks, and it just gives clarity to the whole discussion, and it's something that staff can read and say, okay, I understand that. Here's how it works here. And I've heard of a First Nation near Whitehorse who had adopted a bylaw that kind of created a degree of integration with Yukon's health legislation. And I don't have the name of the First Nation with me right now, but if there were interest, I certainly could get it from the Yukon and pass it on to Abdul. So with all that preliminary stuff, thanks again for inviting Diane and I'm now going to turn it over to Diane to let her make her presentation, and when we get to the question and answers, she and I will do our best to answer your questions. Diane.
Thank you, Ron. So in terms of the questions, before I roll into the slide deck, what I think will run smoother is if you can hold them to the end of the presentation. And what we'll also do is stop the recording at that point so that you can feel free to ask whatever burning questions are on your top list. So there were also some additional questions that I was provided in advance. I have tried to insert those into particular slides where I'm already talking about the specific issues. So we might as well get started. Okay. A general outline, a disclaimer, talk a little bit about us. I'll test your knowledge with a quick true or false, talk a little bit about jurisdiction, access and privacy basics, how you put this all into practice, how to investigate privacy breaches, a few resources, and then we're going to shift into the questions. So our disclaimer, as an oversight body, which I'll talk about in a minute, we always have to start with a little bit of a caution, which is because as an oversight body and we get formal complaints from individuals, and through that process it's very formalized, and once we are engaged in a review or an investigation, the commissioner will have formal findings and recommendations which will be put out in public reports for the most part that are on our website. That is the mechanism in which those formal decisions are made. So outside of that, we have to be very careful. And even with some of the questions that we were posed in the past, and that I'll be attempting to cover off as we move through the slide deck, is everything is based on the facts and the circumstances. And generally, when a question is posed to us, we're getting just a peek in terms of really what's behind the surface. And we really have to examine things thoroughly in order to get to the place where we're able to say yes or no. So through advice, presentations, phone calls, questions and answers, all that the commissioner and I and our staff can do is to provide non-binding general advice. We can talk a little bit more specifically if it was something that was so similar in nature and we know there was a report issued by the commissioner that was available, that we could point to. However, sometimes we still can't delve in too deeply because we do have outstanding confidentiality requirements. So we have to be cautious. So please bear with me when we cannot say a definite yes or no or give you the thumbs up when you are proposing different practices. So our office, just a little bit about us. You've already met the Information and Privacy Commissioner. There are 3 provincial access and privacy statutes or laws that we are responsible for. The Commissioner has already mentioned the Health Information Protection Act. Now, we live in a world of acronyms because everything seems to be such a long title. Even the Information and Privacy Commissioner's office is long. So in terms of the laws, we have acronyms. So the Health Information Protection Act is HIPAA. The Freedom of Information and Protection of Privacy Act, we call that FOIP, and the Local Authority Freedom of Information and Protection of Privacy Act, or LA-FOIP. And what is an oversight body? Well, different terms are used, everything from referee to the umpire in the information age to a watchdog, but it's really about appeal process. So if an individual is wanting access or they're upset that their privacy has been violated, generally we're an office of last resort. We will refer them back to the organization to go through their own internal processes. There is a clock in the legislation in which, on the review side, that they can come to our office within a specific period of time. Privacy complaints, we try to mirror that as much as possible. And if they're dissatisfied with that process or don't receive a response, then we can jump in if we have jurisdiction and grounds. So once again, we would have to test to see if FOIP, LA-FOIP or HIPAA apply. And there's a lot that goes into those considerations, and I'll touch on those briefly today. What is different with commissioners' offices, or sometimes it's the ombudsman in a certain jurisdiction, is in some jurisdictions the commissioner has order making power. Here in Saskatchewan, the commissioner makes recommendations only. So we cannot force any organization to comply with our recommendations. However, there is rights of to the individual, an applicant, or a third party that they could appeal to the Court of Queen's Bench if in fact they wanted to pursue that, but it's on their own dime and we do not have standing. So true or false? Oh, I think it just all popped up. And back that up. Try to do them one at a time. So first question, and before I give you the answer, I will pause to see how well you do. So my first question, patient or statement, and is it true or false? Patient registration information is not considered personal health information. True or false? Well, the answer is false. It actually is, and I will explain later how we arrive at that conclusion. The next, the most common type of privacy breaches investigated by the IPC, our office, are ransomware attacks. False. The most common misdirected faxes that are most common privacy breach that our office investigates are misdirected or errant faxes. And unfortunately, the problem is not going away. And the commissioner will even have a piece in his annual report which talks about the systemic issue. Thirdly, employees that become snoopers most often first look up their own personal information or personal health information. It's true. What we find is a lot of individuals think, oh, it's not so bad. It's my information. Why can't I look it up? But then from there, it's themselves, family members, friends, coworkers, neighbors, bosses, community members, VIPs, and it keeps expanding and expanding and expanding. Fourthly, if an individual wants access to their patient file to sue you, you can deny access. True or false? And it's false. The reason doesn't matter. Either there is a specific legal reason that you can point to in legislation, or there isn't. And then the information, because it's the default is if an individual wants their information, you provide it to them because it is about them. But I'll talk about that about a little bit more in a bit. So what are these laws all about? First and foremost, we talk about two sides of the same coin. And these laws are quasi-constitutional laws because we're dealing with individuals' rights, their rights to access information and the protection of privacy. And when we think about protection of privacy, it is about the information within the records themselves. And so it's all about records in any kind of form or format that you have, which could go back to even microfiche, depending upon how old these records are. And as long as you have them, there are concerns both on the access side, because if someone wants access to that information, you need to be able to produce it, regardless of the medium it's stored on, versus the protection of privacy. The longer you have it, the more there could potentially be a risk that there could be an unauthorized access or viewing or disclosure of that information. So we will talk a little bit more later on about retention and destruction and why that's such an important consideration. But no right is absolute. And in the access and privacy world, which are the two sides of that same coin, is that sometimes there are other considerations that will override. And a perfect example is where an individual's privacy rights, and maybe it's, we all think of the example of COVID-19, a communicable disease. Individuals didn't necessarily want to have to share the fact that they were or weren't vaccinated, but yet there was that overwhelming public interest, and the fact that it was so easily, it could so easily spread, that the public interest did override. And we actually even had regulations that came into force to help make it clear that there was legal authority in order for the collection, use, and disclosure of that information in the circumstances. And so that balancing is always really important. And in terms of our job too, is we talk about certain terms and how they work in terms of access and privacy legislation. But I did want to acknowledge the OCAP principles and values of ownership, control, access, and possession. And when I talk about some of these terms, I'm talking about them specifically in the context of access and privacy laws, either federal or provincial, which is what I'm here to talk to you about today. But just to give you a nod that I do understand, that we are dealing with some broader, really important fundamental values and principles. So before I roll into the landscape around access and privacy laws, two terms are really important. On one hand, we have possession or control, or possession or custody, and on the other, possession or custody, and on the other, control. It's all about the information and where it resides and who has the right to manage it. So when you think about the information or records that you have in your within your systems, paper and filing cabinet, texts on cell phones, you think, well, possession, I can actually reach out and touch it, right? I have it on my actual physical device. I can do a search within our electronic systems. I can access the EMR. I can pull that information out. I can view it. I can use it. I can share it as necessary. That is the physical possession or custody. Those terms are used interchangeably with the different access and privacy laws. Control is something slightly different. And when the legislation talks about the information itself, it's in your possession, custody, or control. Because control is you don't have it in front of you, but you have a right to manage. So maybe your contractor has it. And that's why it's really important, as the commissioner signaled earlier on, that you do have some sort of policy, agreements, bylaws, something that formalizes the agreements or the understanding that all the players have when it comes to who is ultimately making the decisions around this information. Is it you or is it somebody else? You know, if a physician is working for you and they pack up and they leave tomorrow, do they have the right, the ability to take that patient information with them? Because if so, then it would look like they have control over that patient information and not you. So it's something to start to think about, is who should have custody or control. And if you haven't worked out all those details, it's a really good place to start. So let's start with the federal access and privacy laws. I think it's important to speak to how federal is different from provincial in terms of the regime. Here in Saskatchewan, our access and privacy laws, they're together, and we have one information and privacy commissioner. Federally, we have an information commissioner and we have a privacy commissioner. One deals with access to government records, federal government records, and the other to the same records containing personal information in those federal government institutions. However, it's even broader than that when you look at the Personal Information Protection and Electronic Documents Act. It's called PIPEDA. And it applies in provinces and jurisdictions where there isn't substantially similar legislation, at least on with those organizations that are provincially regulated and that are engaged in what we call commercial activity. So even if you go to the butcher shop, or you go shopping in a little boutique, clothing boutique, PIPEDA would apply and protect the personal information of customers in those circumstances. Where you may be of interest is even going back to January 1st of 2001, it applied across the board to all federally regulated businesses, including what we call our FWUBs, Federal Works, Undertakings, and Businesses. Now, we are not experts on PIPEDA, Privacy Commissioner of Canada. That's their jurisdiction, not ours. However, doing a little bit of research to be helpful, what I found, and there's a link on the slide, which I'm sure you guys will have a copy available to you that you'll be able to follow the link. In this early resolution case summary that was put out by the Privacy Commissioner of Canada, summary 2016-03, I quote, First Nation Band Council, when acting in its core functions, will generally be considered a FWUB, and as a result, the personal information of employees of a band council will be protected under PIPEDA. And the specific case was about an employee who was a complainant, was upset because they submitted doctor's notes and they were lost. And so they felt, of course, that was a breach of their privacy. So not to get into, the whole case discussion, the link is there if you want to research it a little bit more. I think it probably is in your best interest because here's an indication that at least when it comes to personal information, not necessarily personal health information, but personal information might be captured in those circumstances because of PIPEDA and its reach here in Saskatchewan. So something for you to look into. And I also provided another interesting document from the Privacy Commissioner of Canada's website, remarks at the 2011 Canadian Aboriginal Law Conference. And it really goes into, how complex the nature of the relationships are, and also depending upon the types of services that we're dealing with, and if it's employees or providing services to others. So I really encourage you to take a look at those. So just a little bit more on FOIP and LA-FOIP here in Saskatchewan. And, we have to look at the jurisdictional piece. They apply to government institutions and local authorities. So generally you think the public sector, you think of taxpayer dollars going towards funding these services, and it's for the benefit of the citizen. So it's everything from healthcare, education, social services, and there's the access provisions, and the access provisions are not only to general records, but also to the personal information of the citizens to which they're providing services. And FOIP and LA-FOIP, they provide for that right of access, but also the right of correction. Because if there are errors or omissions in personal information, maybe decisions being made about the individual are made without all the facts. And as a result, they may have a disadvantage or may be denied some sort of service that they really need. But in part 4 of those laws, there are rules around the collection, use, and disclosure of personal information. So there is a rule book that has to be followed by these players. And if they don't, those complaints can come to our office. And I talked a little bit about the review side. The privacy side, I'll talk about a little bit later. So adding HIPAA into the mix because it makes life a little bit more fun. So first and foremost, HIPAA is different from FOIP and LA-FOIP because it only applies to personal health information in the custody or control of a trustee, which is defined by HIPAA. And no, we don't see the tribal council on the list in terms of who a trustee could be. But I have some examples here that I'll list right away. All government institutions are also considered trustees. So the Ministry of Health, which I'm sure you have dealings with, they are bound by both FOIP and HIPAA. But FOIP deals with personal information, HIPAA deals with personal health information. Some local authorities are also trustees, like the Saskatchewan Health Authority. So that means personal information is dealt with under LA-FOIP, whereas personal health information is dealt with under HIPAA. So we always have to really kind of slice and dice. Whenever there's a complaint or an individual wants access to their records, which law applies, and what are the rules? Even though there are similarities across the board, which really makes it helpful for anyone who is trying to navigate the system and to really make sure there's harmonization throughout because they're built on the same principles. So a little bit more on HIPAA. Just like with FOIP and LA-FOIP, there's a right of access to an individual's personal health information in the custody control of the trustee. There's a duty to protect rules for collection, use, and disclosure. And I will define all these terms later on. A right of correction, and again, complaint mechanisms to our office. So after all of this, where do you fit? Well, the commissioner already kind of laid it out. And the really good news is because as I mentioned, all of these access and privacy laws are built upon the same foundation, the same fair information principles or practices. And even if we go back to PIPEDA, PIPEDA is a very specific law with a schedule that makes two pieces of two pieces of the pie and makes it whole. And it is that voluntary code, which is also interpreted when PIPEDA is applied. And all of those principles underlie these laws. So if you comply with the principles, you also are more likely going to be complying with access and privacy law across the board. Okay. So there's a specific provision in HIPAA. Even if there was some concern about, maybe not being a trustee, that if in fact another trustee was looking to share information with you or someone else, Section 21 contemplates this. And what it specifically does is just ask that, you look to make sure that you're verifying the identity of the person to who the information is being disclosed or shared, so that they know that there's actually a need to know the information should be shared. And then also making sure that, if I'm giving it to you for this purpose, you're not using it for unrelated purposes, which makes sense. And that's consistent with all access and privacy laws. It really is about, you need it for a specific purpose. And unless it's consistent with that, you shouldn't be doing it or using it unless you have consent of the individual. And consent is a factor, because when in doubt, if you don't feel like you have that authority or that comfort with sharing personal health information, then you can consider consent. And I'll talk about consent a little bit later, but there are different forms or types of consent. And there's actually one that's happening right now with this recording that's occurring. But I'm going to come back to that. So now I'm shifting to that one side of the coin, the access to information rights. So my little cartoon, I have no idea how you died. We don't have access to your medical records. So access and correction in HIPAA, which is very similar to FOIP, LAFOIP, and other access and privacy laws, is all about what that process is and what it looks like. So the individual makes a request. They can make an oral request under HIPAA, but there's no corresponding rights to request a review if the access isn't provided. And again, they're requesting information in recorded form. And it is the applicant, it is the data subject, the person to whom the information relates, or someone that is recognized as being able to step in and to act in their place, exercise their rights or powers, the same way that they would be able to. And an example is someone that has consent of the subject individual. If they make a written request, that triggers the formal process, where now a 30-day calendar clock starts ticking, and the information, copies of records, or you can make arrangements perhaps to view. And there's also, sometimes there's some confusion in a health record in terms of what codes or abbreviations mean. And I know we've moved up pretty far away from handwritten notes, but still, if there was, there's some obligations on those that are bound by HIPAA or work within the system to assist the individual so they understand what it is that they're looking at. So if it's simple, you can make copies, you provide it to the individual, there's no problem. However, you may take a look at the information, and there's a section 38 in HIPAA, that talks about some of the legal reasons that maybe you just don't feel comfortable releasing certain parts of that record to the individual. And so you would notify them in a letter within that 30 calendar days, explaining what those reasons are for withholding the information. And if they were dissatisfied, normally that could come to our office and we'd be able to review if we were dealing with a trustee under HIPAA. Similarly, it's important that all organizations that are dealing with personal information or personal health information, they also look at the individual's right to request correction or amendment. And correction, you think there's an error. How do we identify an error? Well, first you get access to the record and you look at it and you go, well, that's not my health services number. It's inaccurate. Here I can prove it. I actually have my card here. I can show you and I can demonstrate that it needs to be corrected. Or there could be an error, or sorry, an omission. And if there's something missing, like a perfect example, you have a patient who is allergic to penicillin and it's not noted on the chart. And then the patient gets penicillin, it could kill them. So you think about the importance, not only from a privacy perspective, but also from an e-safety and patient safety perspective. You want to make sure that you have accurate information on file, just for the benefit of the patients. And again, you're making decisions within the healthcare setting that are in the patient's best interest based upon all the facts. So you need to make sure that all that documentation is there. So privacy, a lot more attention gets paid to privacy because we talk about privacy breaches and all the potential harm that can come to individuals. And on the privacy side, it's interesting because none of the access and privacy laws that we talk about actually define what privacy means. It's an ever evolving concept. And one of my favorite general definitions is the right to be let or left alone. And there are different dimensions of privacy. There's bodily privacy, territorial privacy, privacy of communications. But in terms of these laws in our office, we only deal with one type, which is informational or data privacy. So where I started, this is about information in records, in recorded form. But it can also be broader than that, because we know you can hear information as a healthcare professional, and if you repeat it, you could be breaching confidentiality because you shared it with someone you shouldn't have. And HIPAA is a little different from FOIP and LAFOIP, where it doesn't specify the information has to be in recorded form. It's just the information itself, which I will define shortly. But in general terms, information or data privacy is about the right of the individual, the data subject, to determine for him or herself when, how, and to what extent their personal information or personal health information will be shared. It's about that measure of control. And if you look at how personal information is defined, kind of the easiest way to figure it out is to look at two things. Do we have an identifiable individual? And is the data elements that you're talking about personal in nature? So if you put those two together, generally it'll be considered personal information by pretty much any privacy standard. Uh, there are some slight differences from jurisdiction to jurisdiction, so you really do have to look at the applicable privacy law to learn a little bit more about what's in and what's out. And one of my favorite ones, because it comes up not only in a personal but in a professional a situation all the time, and it surprises a lot of people, which is that my opinion about somebody else is not my personal information, it's theirs. So just turn your mind to what that might mean. Privacy laws will also define what is not considered personal information. So for instance, if something is sufficiently de-identified, you strip away all of the direct identifiers, maybe even some of the more unique ones, and you present the data and you can't figure out who it is, then there's not really any privacy interests. Or you're providing stats or aggregate data. So if that's the kind of request that someone's looking at or that you have to share, you shouldn't even blink. You should be able to share that information um, without fear that you're breaking a law. What's also not considered personal information is anything around the jobs that we do. So the work product that we produce. And even though we may sign something, that doesn't make it my personal information. You're doing it only because you work there. And so it actually is records that should be in the possession or control of the organization itself. But again, HIPAA has nothing to do with general records, your operational type stuff. It's all about the personal information of either patients or employees or even their family members. And business card information. It's carved out in PIPEDA as well, because it's about the job. It's not necessarily about me. And if I stop being the deputy commissioner tomorrow, somebody else would take the job on, and they would have the exact same address information and contact information that I would have had. Workplace observations are also not considered personal information because, again, it's what you do in the course of your job. And an example would be if a person commented on, the temperature in the room, right? That the fan was blowing. Well, that's just an observation, right? Maybe it's in the context of occupational health and safety inspections or something, but it's not about another person. And it's not about their personal views. It is something that was noted in the course of their work. However, where it shifts is when we're looking at what's called employment history. So what I do from day to day, including my job description and the tasks that I perform on a daily basis, is not considered my personal information. But when you actually evaluate me, that is considered my employment history, how well I do or don't do my job. Or if you look at a resume, that is personal information and it needs to be protected. So personal health information, just shifting gears a little bit. When we look at HIPAA, it defines it and it's like a long list of what's in, and it includes the physical or mental health of the individual, health services provided, donation of bodily parts or substances, like I mentioned earlier, registration information, but also what's incidentally collected, as the individual is perhaps being seen by a physician. And I think that's helpful because it just makes it clear that pretty much anything that's being collected in the course and provision of health services should be considered personal health information, because you really don't want to have to go in and try to slice and dice and figure out, well, this really should be personal information and this is personal health information and different rules apply. It really makes life a lot simpler. And registration information, if you're looking at FOIP or LAFOIP, generally things like name and contact information, things like that would be considered personal information instead, but under HIPAA is recognized explicitly as personal health information. And what's broader is we know that on any patient chart, in any EMR, or if you're looking at the EHR viewer, there's not only going to be information about the data subject, but there's most likely also information about family members. And perhaps others. I think of how common is it to ask, when you're first assessing a patient, is there any family history of cancer or heart disease or whatever else? And that kind of information gets recorded. And so this is where there can be some commingling, but still ultimately is about the data subject as well as others. As I mentioned, HIPAA doesn't apply to those general operational records, personal information, the de-identified statistical stuff, but also, and this is important when we get to the record retention disposition considerations, that HIPAA wouldn't apply, similarly FOIP and LAFOIP, if the person has been deceased for more than 30 years. FOIP and LAFOIP talk about 25 years, but HIPAA is very explicit with 30. And it definitely doesn't apply if the records are more than 120 years old. But then again, who has records going back that far? So privacy basics, this is really when we start getting into some of the meat of it all. And I like to start with the confidentiality definition, because it gets a little bit confusing sometimes because people use it in different contexts. And first and foremost, when we think of confidentiality in the privacy realm, it is about the duty to protect the personal information or personal health information that is shared um, with the individual, the professional, in the event that they have to, share it with somebody else. They're only doing that with authority. So it's really about a trust relationship. And if a patient doesn't trust you, they're not going to share their information, or they may not be truthful. So it's really important that there's a trust relationship that's built. We also hear about confidentiality, though, when it comes to proprietary information, which is more something we would deal with on, the access side in FOIP and LAFOIP when we're dealing with business type records, cabinet confidences, solicitor-client privilege, third-party business information or trade secrets. But there are no privacy interests involved in those cases because we're not dealing with people, natural persons, or individuals. We're dealing with the artificial, the corporate world, the business world, the government records. And so they're different types of confidentiality. And it's just really important to understand the difference. I already mentioned the importance of accuracy, and there are those rights of correction or amendments on the access side, but also there's that obligation that if you're disclosing personal information or personal health information, that it is as accurate and complete as necessary for those purposes. Because again, there can be harm that could come to the individual if in fact that information is inaccurate. Collection, use, and disclosure, promise to define those terms. Collection is acquiring, it is receiving, it is somehow bringing the information within your systems, your record holdings. It's becoming aware, knowledgeable of that actual information. And it comes at us in a lot of different ways, but often it is from talking to the data subject and recording that information, and it's dictated and ends up in records or transcribed. Use is what happens to the information internally. And if you think about it, with Meadow Lake Tribal Council, you think of all of your different, the employees that you have, any contractors, the different services that are provided. Maybe there's some satellite offices. You're dealing with the whole umbrella of the organization. And as the personal information or personal health information is being shared amongst those that work for you or are providing services on your behalf, that is considered a use. It's not a disclosure. So you still have that information. You haven't lost control over it. Disclosure is different because, and we call these data transactions. Disclosure is different because you're actually giving the information away to some external party or individual or organization. And you're losing that control because they now have it. And you can't necessarily dictate what they do with it unless, of course, they are bound by an access and privacy law or an other legislation that requires them to follow the rules. Or again, you have some sort of written agreements or understandings that clearly specify, what those limitations are. And I'll talk about that some more in a little bit. And so understanding what that data transaction is important because in these access and privacy laws, there are specific sections that deal specifically when that information can be shared with or without consent, which we can't lose track of. But if you're looking at, the fundamentals again, purpose is so important. If you look at why patients will provide their information in the first place, the original purpose for which it was collected, it is fulfilling the specific mandated services, you're offering your programs and activities that they're seeking. And so it seems to make sense that the individual is offering their information to you for these purposes and that you can therefore then use it in order to provide those services to them. And some consistent ones. So for instance, you have the information for, providing health services, but you also maybe have to bill for it, right? You have to get paid for it. And so it's a consistent use or purpose to then use that information without consent for billing purposes. So that would be completely legitimate. There are also recognized secondary purposes in the legislation that don't necessarily really neatly fit back to the provision of health services, but they are authorized anyways by the specific law. And to give an example of that, in HIPAA, well, in every access and privacy law that I'm familiar with, they have a specific provision where limited information can be shared if it would help to ensure that if there's reasonable grounds to believe the disclosure will avoid or minimize a danger to the health or safety of any person. And I know this one had come up in some previous discussions that I've had, where you think about someone who has been assessed as being potentially suicidal. And in that case, you don't need to get the consent of the data subject because they're probably not going to give it anyways. But then you can communicate that information maybe to law enforcement in order to intercede, to try to intercept, bring that young person in to receive some psychiatric care or what have you, just to make sure that you're doing what you could. But there's a lot that goes into making that kind of a determination too. The person should actually have be able to do that kind of a formal assessment, because it is again on a reasonable basis that you would make that call. So these secondary purposes, like I said, again, not necessarily directly related to why the information was provided in the first place, but there is authority recognized in the legislation for that sharing without consent. So that's key. What is authority? So specific provisions you can point to in a law or bylaw that says, yes, we can share for these specific purposes, and it's really clearly laid out. And you want to make sure that all of the people that work for you understand what the rules are, but ultimately wherever there's question, they should also know who to go to ask to get the direction they need. So they're not just sharing the information when they're in doubt. They're actually pausing if necessary. But if there isn't that clear legislative authority, then there is consent. And I promise to talk about this. The different forms of consent, and all three are recognized by HIPAA. We have express consent, implied consent, and deemed or no consent. Express and implied consent both are a higher standard because the individual has to be informed. They have to be knowledgeable. They have to understand what it is that they're getting themselves into and what the nature and the consequences are if they don't provide that information. And then they're making a choice. And with express consent, it's an opt-in. So they actually have to say, yes, I consent. And it's either verbal or they sign it on a consent form. With implied consent, it doesn't require any formal, signing of papers or an actual yes. It's usually considered more of an opt-out. So the person would have to choose, take an action to not participate, to not have their information collected, used, or disclosed. And it's by the person's actions that you can actually assume that the individual has consented. So back to, like I said, the banner in this recording. there's a little caution symbol, and then it says, recording and transcription started. By attending this meeting, you consent to being included. It's a perfect example of implied consent. And if I did not want to participate, I would have to opt out by clicking out, leaving the meeting, and not being recorded. So perfect example. And if someone presents themselves for health services, and you've talked about, that may have to get the lab involved, may have to have other healthcare professionals involved, make referrals, have the person actually go and see somebody else. I think in those kind of cases, implied consent may also offer some comfort because it's clear that the patient is there seeking um, or you're arranging, assessing, providing, continuing, supporting diagnosis, treatment, and care, and that's what the patient's there for. And these are all those primary purposes for which the individual walks through your front doors. So hopefully that helps a little bit. A reminder too, when we talk about consent though, it's not consent for treatment. We don't want to get the two confused. This is consent for the collection, use, disclosure of personal health information. That's it. And those underlying principles, again, all privacy laws have them. The need to know principle, I'd like to start with that one. A lot of times our office will hear, oh, well, can't we share that information because, the healthcare professionals or individuals are within the circle of care. Circle of care is not found in HIPAA, need to know is. Circle of care, when I have had discussions in the past with trustees, they would present to me these kind of, concept maps where there'd be a circle, and inside the circle, there are certain professionals that are always in the circle of care, some that are on, on the actual line itself, and others that are always out. Well, it's not static. It changes from day to day, depending upon the role that the individual is playing at that time and the patient's needs, it may shift. So it's very episodic. And even if you look at, for instance, a physician who maybe wears a number of hats, they're working, they have privileges to work in some healthcare facility, and they're just working in the acute care setting, and then they go back to their clinic. Well, the type of services that they're providing in one context, may end, and then the patient is released back into the care of their family physician, right? So it's looking at what are the needs in the particular situation, and if there can be that professional judgment, looking at the circumstances, they make the call, and the information is shared that's necessary in order to provide those services. But what also has to be respected is the other principle, which we call data minimization. And it is providing the least amount of personal information or personal health information that's necessary for the purposes, and it's at that specific time. So if only 5 data elements were necessary, then don't ask for another, right? A sixth. Really stick to what information is necessary at that time. But there's a lot of professional judgment, that goes into making these calls, and it's something that would have to be assessed on a case-by-case basis because there are a lot of factors that come into play. So just to pause for a second, because there were a number of questions that were raised, and I'm just going to see if I can see them here on my screen. The first one was about healthcare workers sharing information about a client, 16 or 17-year-olds, if the biological parent asks, and then it goes more into if they're not the legal guardian, and what if the child tries to commit suicide, and more about a 13-year-old. This is what the commissioner was talking about at the very beginning in his opening remarks, is that there's so much that goes into the decision making around making these calls that you really do have to have a solid set of facts before you start trying to figure out yes or no. So here's a case where I think it's probably best that you seek some specific legal advice on that. And then another one, in situations where a therapist can't obtain parental consent and a child is at risk of suicide, can the therapist still provide care to the child without consent? As I indicated, HIPAA isn't about consent for treatment. It is about the sharing of personal health information. The next one, if people call the receptionists at a clinic, can they ask if a patient is at the clinic? This can be an inquiry to verify that a family member arrived at the clinic. Maybe this community doesn't have good cell reception. This is something that we've heard a lot over the years where, you know, people are just either they're curious or they just want to know if it's a family member. They're concerned. They want to be able to maybe go down and visit. HIPAA has a specific provision that information can be provided without consent if it is to the subject individual's next of kin or to someone to whom they have a close personal relationship. So then you have to ask the question, how do you assess that? How do you know when someone calls that they are actually a next of kin or to someone to whom they have a close personal relationship? So I'm going to let you work that out on your own, but just know there is a specific provision in HIPAA that contemplates that. But also that same section talks about that you should take the express wishes of the patient into consideration. So for instance, if the individual comes into care, they're in the ICU and they say, well, please put a flag or advise the staff that I'm just not on speaking terms with any of my family members. So if they ask about me, please do not provide any information. Right. So that's what I'm talking about is how do you even make a note of that so that others will be aware of it. So it comes back to those processes that you have in place. The next one, how do you recommend we address health staff who disclose personal health information at work? And I wasn't sure if this was employees just volunteering their own personal health information or if they were disclosing personal health information that perhaps was overheard by somebody else and it was inappropriate. So if it's just they're sharing their own personal health information, they have the right to do that. Um, uh, if it's disclosing personal health information and they shouldn't be, we'll talk about that a little bit more when we talk about investigating privacy breaches. Just a couple more questions. So can the Community Emergency and Planning Committee request a list of patients with disabilities to add them to the community preparedness plan? In the case of forest fire, they will want to make sure these individuals are assisted. Some of these individuals are elderly with no family around. So this comes back to purpose, right? For first and foremost, HIPAA is about the necessary sharing of personal health information for diagnosis, treatment, and care, not for community emergency planning. And, specifically, if you're looking at the secondary purposes in which personal health information could be disclosed without consent, it may or may not be on the list. Probably most likely not. So here's one of those circumstances where, because it's not happening right now, this isn't an emergent situation today, perhaps you'd want to actually work in and get express consent of individuals before you would just add them to the list. On the need to know principle and minimal information, for example, a client has leg pain. Does the physiotherapist need to know? Well, is it necessary for diagnosis, treatment, and care? I think that in that case, there might be a case to be made. What of the dietitian? Probably a harder case to make, if not impossible. But again, you can't prejudge these. You would have to determine at the time if it was appropriate or not. And can these health professionals access the patient chart for this purpose without consent? Again, like I said, they would have to specifically demonstrate that there is some sort of causal connection to the information they're seeking and the services that they're trying to provide. If an external body is conducting a privacy investigation, can MLTC release information to that body? For example, the SRNA inquiring on nurses' documentation. Rule of thumb, if you're in doubt, and again, this is not diagnosis, treatment, care, so it sounds like it falls into the realm of secondary purposes, ask them what their authority is to collect it. Because if there's an actual legal authority or instrument that they're relying on, they should be able to provide that to you. So specific law, specific sections, and then of course you would still have to take into consideration data minimization principle and what have you before the information is shared. Okay. And I know all of this entire slide, it's not just about information that you, again, have in your custody, but that you also have access to. right? And it's not necessarily even in your control, it's in somebody else's control. So we think about, and I gave the example earlier about the electronic health viewer, and that is somebody else's, the data within it is in the custody control actually of eHealth Saskatchewan, just like the Pharmaceutical Information Program, or PIP, is actually within the custody control of the Ministry of Health. So they have different responsibilities, but they still allow different healthcare professionals, and some are trustees, some aren't, to get access to these systems. And so what kind of things do they put in place in order to make sure that privacy is being respected? And some of those are safeguards. And I'll talk a little bit more about some of the written agreements and things that are in place that you're probably already aware of, because you don't get access to these systems without actually participating and cooperating. But safeguards is what you do in order to help protect the information from unauthorized, from the snooper, from inadvertently going to the wrong place, like a misdirected fax, or to be stolen by, a cyber attack, or your system fails. Right? You think of disaster continuity planning. You have to also make sure that what happens in the event that there's a flood, and all your records are now destroyed because there was a flood, or even something as unexpected as the sprinklers go off in the building, and all of a sudden everything that it touches is now destroyed, because technology and water don't mix very well, and neither does water and paper. So something to really think about: what are you doing in order to protect that data? And when we look at access and privacy laws, they talk about three different types of safeguards. And again, these are controls. They are administrative, technical, and physical. So administrative are more so your operational type things. So your policies and procedures, the type of training programs, orientation to new employees, which also should have that training first thing when they join the organization. Otherwise, they may not really understand what they can and cannot do, and you're more likely going to have them do something that's inappropriate because they weren't trained. Technical, the obvious ones are things like having strong passwords. And by the way, using anything related to your family, your kids, your dog, those are not good passwords because they're easily guessed, and others would be able to get into your system with ease. So you really have to think of some strong passwords. But it's also having things like your firewalls in place, and making sure that maybe it's VPN access or what have you. Physical safeguards are the obvious ones too, where we're talking about locked doors, locked filing cabinets. You have security systems in place, so that you can make sure that you're doing everything you can to eliminate the risk, mitigate the risk, or if there's nothing that can be done, accepting the risk, but at least making sure that you're making conscious decisions before you go forward. And it's really about protecting the life cycle of the information. It's not just from collection, it's all the way to destruction. And our office has seen too many complaints where the information, it went to recycling instead of getting destroyed. We actually had a case where records ended up in chicken coops. And, it should have been destroyed, but instead it was the chicken coops. We've had our analysts, our investigators have to go out and pick up um, uh, pages of personal information that were blowing around in the wind in the ditches because they flew off the back of a truck. So it's really looking at, even if we're sending or we're getting some sort of a company to come in to do destruction, how do we do that in a safe manner? And having something like certificates of destruction, doing witness shreds if information is really sensitive, doing it yourself is just one more step towards making sure that that information isn't going to end up in the hands of somebody that it shouldn't. And on that, I mentioned earlier, you have to look at record retention and disposition. And really, how long do you need to keep personal information and personal health information? Because the longer you have it, the more likely there could be some risk that comes from that. But you do need to retain it, because if you're seeing a patient on an ongoing basis, you need that history. So it's something that just can't be easily discarded. And HIPAA, like other laws, it dictates that, there's ongoing duties of the trustee. So even if, one, let's say it was a physician in private practice, they decided that they were quitting tomorrow, well, they're still responsible for those records. Right? They just can't throw them in the trash and say, no, I'm done. They actually have to retain those responsibilities and still provide access to patients and what have you, or they can hand it off to another trustee that takes the responsibility for those records. However, if a patient doesn't want to go to the second trustee, that's their right. They can choose to see whatever healthcare professional that they choose. However, the records are in the custody and control now of that second trustee. But even if a trustee dies, it's actually the personal representative that gets tasked with that responsibility. So, these duties continue on, and the other kinds of considerations is not just patient access, right? Because maybe they want their patient records transferred someplace, but also in terms of just protecting yourself. Like maybe there's records you need to keep for other legal purposes. Maybe there are financial audits. Maybe there is investigations. So you really have to look at what the needs are that must be met when you're looking at coming up with these record retention disposition schedules. And a lot of the regulatory bodies out there, they have their own administrative and regulatory bylaws that spell out things around record keeping and record retention. So it's something to investigate, also to see if there's other laws that may have requirements, and to kind of work all of that in when you're making your decisions. So put it in writing. This is what I was talking about, is when you're looking at all these different types of working relationships with other healthcare providers, information management service providers, we call them IMSPs. Generally, those are the types of organizations, companies that you hire to do information management or IT support. They're storing your information. Maybe it's a cloud provider. Maybe they are, going through and they're de-identifying data for you. There's a whole bunch of different types of arrangements that you could have, and that's spelled out in Section 18 of HIPAA. But it's important to have written agreements with them so that you can be clear. What is the purpose of this relationship? What is the information that's involved? And with IMSPs, the trustee stays in the driver's seat. It's clear in those written agreements that this information is being provided to you, IMSP, only for these purposes, which you're providing on my behalf. However, if in fact we terminate these agreements, the data comes back or it's destroyed. And so it's maintaining that custody or control, which is really important. And also those written agreements will say, okay, IMSP2, I know you have it in your physical possession because you're providing services for us. However, you can't use it for your own purposes, and you can't use it and share it with, other third parties to which you do business, which is important because if you're going to safeguard the data, you have to make sure that everybody knows what the rules are. So it's about accountability and compliance. And if there was a privacy breach, are they going to work with you? If that's not spelled out explicitly, then, maybe you're going to have a problem if all of a sudden there's a privacy breach and you're not getting timely information about what's happened to the patient data. So really being clear. And, if it's a vendor, you're looking at your electronic medical record, you know, are there mechanisms in place too so that you can test to make sure that the people that are accessing that information, whether they be administrative or healthcare providers, that they're not abusing those privileges, that they're not snooping, looking at their own information or others? And so do they even have that technical capability and spelling in obligations for things like perhaps proactive auditing? Right. And so you're doing what we call same name lookup to see whether or not that might be occurring. And so you spell it all out in writing, and then at least there's, better hope for accountability across the board. So this next little cartoon, hello, is this the doctor's office? Thank you for sending me all that information, but my name isn't Amber and I'm pretty sure I'm not pregnant. And of course the little cartoon has a senior citizen. So that's a perfect example of accuracy issues and a privacy breach, which is the next part of the presentation. So what is a privacy breach? And we hear about it all the time too, a security breach or an incident versus a privacy breach. Well, a security breach can occur without personal information being involved. But if there's personal information or personal health information, it's a privacy breach. So if there isn't personal information or personal health information involved of an identifiable individual, there is no privacy breach. So that is, one of the first things to work out. If there's a cyber attack or, someone claims that they were told something else, are we even dealing with information to which there's some privacy interests? And if so, then we have to stop and pay attention. The most common ones are the collection, use, or disclosure without authority. So, it's not being used for the purpose for which it was provided. Often it's just because someone wants to gossip, they're curious, they just think it would be nice to know as opposed to there's a need to know. And in those circumstances, in response, you should take some immediate attention to try to contain the breach and to provide notification to affected individuals if you in fact know who that is. And a perfect example is you accidentally, or somebody that works for you for the tribal council sends an email, and instead of blind copying a whole bunch of people, all the emails were included in the to line so that every recipient of that email can see the actual email addresses of everybody else. So that would be a privacy breach. So containment would be about, well, can we have IT go in there and, uh, recall those, pull those back from those that haven't even opened their Outlook, for instance, that day. Do we contact those individuals and ask them to triple delete, and to not share that information or forward it on to anybody else? What are those steps to help, put the genie back into the bottle if possible? And the sooner it happens, the better, because there's less likelihood that there could be some risk to the individual, like for instance, identity theft. And notification, um, it is about notification to the affected individual, the person to whom their personal information has been involved in a privacy breach. But there could also be notification to our office in terms of proactively reporting that incident so that we can help provide some advice and direction in terms of what comes next. And then, of course, there should be a formal investigation looking at the root cause, trying to figure out why this happened and what could be done to prevent future breaches. And in the cases where there isn't any training, policies or procedures, job descriptions, and someone's, second day on the job and they try to do something without any direction, well, I think it's pretty predictable, that something was going to go wrong because, there weren't efforts made to make sure the person was doing things in a privacy respectful way. And privacy breaches can be unintentional, accidental, or they can be intentional. Like the cases of employee snooping, and it can be malicious. And there are actually offense provisions in FOIP, LA-FOIP, and HIPAA if you knowingly or willfully violate the act. But that's a whole nother discussion for another day. So a couple of questions that I think are associated with this slide. Do we need a notification policy and timeline? If a breach occurs, how long before a patient is notified is considered a reasonable time? What if a patient can't be reached? So a lot to unpack in that. And yes, the more specific, direction that you can provide to those that work for you, and in terms of who would take responsibility in these specific cases, is helpful, because a lot of people too aren't going to be able to confirm that a privacy breach has occurred. So who within your organization should be tasked with making that kind of a call? Notification, the sooner the better, because if in fact the individual needs to take steps to help protect themselves, that should happen sooner rather than later. But it's reasonable efforts, not heroic ones. So if you can't reach them, maybe by phone or letter or email, and depending upon if privacy breaches involve like a large volume of individuals and maybe the data goes back a long time, we have made recommendations to public bodies or trustees that sometimes you just need to go public. Right, you get the media involved, put some notices on your website, social media, just reach out to try to give people some idea what the scope is, and then they can self-identify and come back to you, and then you can see if they actually fall on the list of who is affected and who wasn't. And what if patients can't be reached? Sometimes you can't, right? And maybe they're deceased. So it does take, unfortunately, a lot of work depending upon how big the breach is. Next question, if communities hire staff without the appropriate credentials or training and a privacy breach occurs, who is liable? From our perspective, we're looking to see, first and foremost, if a privacy breach occurred, and then as the steps are indicated on the slide, if all of that has occurred. So we're looking to see if the trustee has responded appropriately to the breach, and we just make recommendations. So it's not about you know, trying to say, well, this individual is liable. I guess where there's a bit of that shifting is if there was in fact an offense that was committed, but that is a huge complex discussion, and again, for another day. So the role of the privacy officer, who should make the call in terms of, if a privacy breach has occurred, or if you need to be providing notification to affected individuals. Generally, within organizations, and our office will ask, who's your privacy officer? And it can be a standalone position, or it can be responsibilities tacked on to another. But generally, if someone within the organization that has the expertise, some training and access and privacy, that will be that first point of contact that you can deal with individuals directly if they have concerns about access to their personal health information, correction requests, or they have concerns about privacy. So they usually would start with that person. If there was any kind of response that has to be provided, they would do that. So they have the authority of the organization to intervene in those specific matters. And even broader than that, so not just responding to those requests and complaints, but it'd be working with our office in the event that we had jurisdiction and we were able to undertake an investigation. Because even if the tribal council wasn't directly involved as a trustee, sometimes we find organizations kind of get pulled in because there's a privacy breach involving the other side, right? Because it really is a two-way street. If you look at two different organizations that are sharing data, one collected, one disclosed, right? So it's really looking to see, what both sides did in order to make sure that it was appropriate in the circumstances. So, it's working with our office and finding out and getting, really familiar with what's necessary in order to make the case, right? To show that you've done your due diligence, done everything appropriate in the circumstances. But broader than that, it is looking at the privacy culture. Is conducting privacy impact assessments, working on the privacy policies, implementing them, doing the training and orientation, just doing everything that they can to make sure that everyone understands what those obligations are, and they're really rising and following best practices on a daily basis. Mistakes will still be made. We're not perfect, but it's looking at learning from past mistakes and making improvements going forward. So in terms of our investigations, I talked a little bit about reviews. If we were investigating, generally it's because a complainant has come to us and they've already complained to the organization. Sometimes the organizations proactively report to us, which is helpful because then we can really provide that advice and direction at an early stage. And sometimes there's parallel investigations going on with our office, the ombudsman, regulatory bodies, and others. And we all have different mandates and roles. So we're looking at different things, but it all might come out of the same incident. But we try to make sure that we're clear in terms of what our role and authority is as we go forward. And it is looking at jurisdiction and grounds. And same with a review, it might result in a public report or it may not. But we never name applicants or complainants because, of course, we're protecting their privacy. But we do name the organizations in question. A whole list of resources for you to take a look at, everything from e-communication, auditing and monitoring, how to prevent misdirected faxes, privacy agreements for trustees, mobile device security, best practices for transporting personal health information outside the office. And you can imagine we've come up with a lot of these resources because there are breaches involving a lot of these different issues. And so, coming out with guidance material is something that our office does to try to help you get your head wrapped around what do you need to do to make it less likely that it's going to be a problem in your backyard.